Namaskar. Friends, you are watching the video channel Disciplinary Proceedings. Friends, this channel was started about 3 weeks back when I had prepared and circulated a introductory video. Thereafter, I also made a video on Article 311, which was also published on this video channel. I had mentioned that I will be uploading one video per week on the various concepts relating to disciplinary proceedings. I'm sorry that I could not upload any new video for last 2 weeks, especially because of my health conditions, and I also run a video channel in Marathi titled as Karmachari Mitra. There I upload 2 videos per week, and therefore I could not upload a video on this disciplinary proceeding in the last 2 weeks. But now henceforth I will ensure that at least one video is uploaded every week on this channel. Friends, in the last video we discussed about the provisions in Article 311 of the Constitution, which provides a special protection to government servants. I don't want to repeat that provisions, but the main emphasis I would like to say, invite your attention, that the Article 311 says that no person can be dismissed or removed by an authority which is lower than the authority which appointed him. Then there is a provision that no person can be dismissed, removed, or reduced in a rank without holding an inquiry in which charges are explained to the employee and he is given an opportunity to say his say on those charges. There are certain 3 exceptions also which we consider on that way. The first exception, no departmental inquiry is necessary when a person, a penalty of dismissal, removal, reduce or wrong, or any other penalty is imposed on the ground of his conviction on a criminal charge. Second, no departmental inquiry is necessary when it is not reasonably practicable to conduct an inquiry. And who is to decide whether it is reasonably practicable to conduct inquiry or not? It is the authority which has the powers to dismiss or remove the employee. Of course, though the decision of the disciplinary authority or appointing authority is final, the courts and tribunals can certainly interfere and find out whether it was really reasonably practicable to conduct inquiry or not, and whether the disciplinary authority has recorded the reasons as to why the departmental inquiry is not reasonably practicable to be conducted. And those reasons are to be recorded in writing before imposing the punishment. And third exception, that when the president or the governor, as the case may be, is satisfied that it is not reasonably practicable to conduct an inquiry. These were the 3 exceptions. One provision in the Article 311, which was inserted by an amendment, we would like to invite you. When a person, after an inquiry, after the evidence is recorded, on the basis of evidence adduced in the departmental proceedings, a penalty can be imposed against the delinquent employee, and it is not necessary to give him one more notice, asking his presentation or asking his say on the proposed penalty to be imposed. This is very important, which needs to be. Now friends, apart from these implications, what we are going to see in today's video is when the Article 311 is applicable and when the compliance of Article 311 is in order. Because we had seen the Article 311, etc., and had a discussion in the last video. Now today what we are going to see, when the Article 311 is applicable. Now Question always arises whether Article 311 is applicable to ad hoc employees, temporary employees, or probationers. Now, in case of ad hoc employees, now I would like to invite the attention to a well-known case of Jarnail Singh versus State of Punjab. And the court has come to a conclusion, has observed. I will read the para 33 of the judgment. The judgment said, position is now well settled on a conspectus of the decisions referred to herein before, that the mere form of the order is not sufficient to hold that the order of termination was innocuous and the order of termination of a service of a probationer or an ad hoc appointee is a termination simpliciter in accordance with the terms of appointment without attaching any stigma to the employee concerned. What the court has said, it is a well settled position now that ad hoc appointees are also entitled to the protection of 311 of the Constitution as permanent employees are entitled. Ad hoc employees have no right to hold a post. But however, if the services of ad hoc employees are terminated on the ground of misconduct, the compliance of Article 311(2) is necessary. Now, many a times, the disciplinary authorities may issue an order of termination in innocuous form. But then, it is incumbent on the court, what the Supreme Court says, it is incumbent on the court to lift the well and to see the real circumstances as well as the basis and foundation of the order complained of. In other words, the court in such case will lift the well and when see whether the order was made on the ground of misconduct, inefficiency or not. Now, if it is made on the ground of misconduct, then naturally provisions of Article 311(2) have to be complied with. So, in short, in case of ad hoc employees also, provisions of 311(2) are required to comply. Now, let us consider another applicability, whether it is applicable, provisions are applicable to temporary employees and probations also. Now, in this case, a very old judgment of the Supreme Court, which is still referred to in many cases of the disciplinary, is Purushottam Lal Dhingra versus Union of India, AR 1958 AC. What the court says, now it is well settled that the temporary government servants or probationers are as much entitled to protection of Article 311 of the Constitution as the permanent employees, despite the fact the temporary government servants have no right to hold the post and their services are liable to be terminated at any time by giving them a 1 month's notice without assigning any reason, either in terms of the contract of service or under the relevant statutory rules regulating the terms and conditions of such service. The courts can therefore lift the veil of innocuously worded order to look at the real face of the order and to find out whether it is as innocent as it is worded. And therefore, in short, the provisions of Article 311 are applicable to temporary employees as well as probationers also. One more judgment I would like to invite your attention is Chandra Prakash Shahi versus State of AP in 2000. Para 28, it says, the important principles which are deducible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold a post and his services can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post in question. It is for the determination of suitability of the probation for the post in question or his further retention in service or for confirmation an inquiry is held it is on the basis of that inquiry that a decision is taken to terminate the service. The order will not be punitive in nature. But if there are allegations of misconduct and an order terminating the services is passed on the basis of that inquiry, the order would be punitive in nature as the inquiry was held not for assessing the general suitability of the employee for the post in question, but to find out the truth of allegations of misconduct against him, that employee. In this situation, the order would be founded on misconduct and it will not be a mere matter of fact. So, in short, when an inquiry is held to find out whether the probationer has committed misconduct, now in that case, the compliance of Article 311 is necessary. But however, if the inquiry was just made to find out his suitability for the post for which he was recruited or his appointment was made, now in that case, if the order of termination will not be punitive because the objective of inquiry was not to find out whether he had committed a misconduct, but it was the inquiry was made with an intention to find out his suitability or otherwise. Now, friends, now I will just quote some instances where compliance of 311(2) is not required. As I said, if any penalty is required to impose, compliance of Article 311 is required. But there are instances where it is not required. First, now a provision does exist in service rules of the central government employees, empowering the government and the appointing authorities to prematurely retire an employee in public interest. Now, the motive behind such provision is to remove the dead wood and the mane of lack of integrity and improve the efficiency of the service. And therefore, there have been circulars where a review of the CRs is made after an employee attains the age of 50 or completes his 20 years. And such review is made. And if a person is found to be has become a dead wood or he lacks of integrity, the authorities can decide that instead of conducting any further inquiry, such employee can be compulsory retired in public interest. And if such employee is retired in public interest or compulsory retired in public interest, compliance of Article 311 is not required. Now, in many times in the government also, an appointment is made for a specific period. And naturally, his appointment will come to an end at the end of the said period. And his services will stand terminated. And therefore, naturally, the question of holding any departmental inquiry does not arise. And therefore, question of compliance of Article 311 is not required because his appointment was made for a specific period and it's bound to come to an end after the end of that specific period. Third, again to recapitulate, the provisions of Article 311 are applicable to civil servants or persons holding civil posts. They are not applicable to the employees of state-owned corporations. For instance, state trading corporation, mining corporation, there are a number of corporations. No, the employees of those corporations are public servants, but they are not civil servants. Every civil servant is a public servant, but every public servant is not a civil servant. And therefore, provisions of Article 311 are not applicable to the employees of state-owned corporations. Now, many times, illegal appointments are made because for recruiting persons on any post under Article 309, under proviso to Article 309, rules are made by the respective governments. And while giving an appointment to anyone, the rules are required to be complied. For instance, if the rules provide that the advertisement is required to be given in the local newspapers, and if no such advertisement is given, an appointment made, naturally, such appointments are illegal. And therefore, while terminating the services of the employees whose appointments are illegal, the compliance of 311 is not required. Many times the employees suppress certain facts. And for example, an employee before joining the service is required to give a declaration whether there are any police cases were filed against him, whether there was a conviction in the past, etc. Now, if an employee gives a wrong information and suppress the fact of his imprisonment or conviction in the past, naturally, such appointment is obtained by suppressing a fact. And therefore, naturally, the employees who are appointed by suppressing the fact by the employees themselves, then such appointment is also illegal. And while terminating the services of the employees who have obtained the service by suppressing an important fact, compliance of Article 311 is not required. One more category, appointments obtained by committing fraud. Now, when appointments are obtained by producing or submitting a false certificate, suppose a post is reserved for scheduled caste and an employee obtains the service by producing a false certificate that he belongs to SC. And naturally, when it is noticed later on, his service or his services can be terminated, and while terminating his services, no compliance of Article 311 is required. One more category I will like to say. A person is appointed to officiate on a certain post, say for a temporary period, say maybe on a promotion on a higher post. Now, when he is reverted to a substantive post, no compliance of Article 311 is required, because he is not being reverted on the ground of misconduct, and he was officiating on a such post, and therefore compliance of Article 311 is not required when a person is reverted from officiating to a substantive. There are many occasions when the services are required to be terminated because the post is abolished. In such circumstance also, the compliance of Article 311 is not required. Now, many times, services of the employees, especially probationers, are terminated, and which is called termination simplicity. It is, as I have already explained earlier, that probationer is a probationer till he is confirmed. And therefore, during that probation, the government has every right to find out whether he is suitable for the post for which he is required. And if it is found that he is not suitable for the post for which he is required, the government has every right to terminate his services. And the order of his termination will be called termination simplicity. Now, in such cases also, compliance of Article 311 is not. Friends, in today's video, what we have seen? We have seen what are the implications of Article 311. Then what we have seen that when the provisions of Article 311 is applicable, in which categories of employees, for ad hoc, temporary, probation, that we have seen. And then last, what we have seen is when the provisions of Article 311 are not required to be complied with, or the cases where compliance of Article 311 is not required. Friends, I will stop at this stage. We'll meet next week on certain a new topic or relating to disciplinary proceedings. Friends, if you like this video, please like it, share it, and subscribe to the channel if you find this video fruitful to you, beneficial to you. Namaskar.